Welcome to Immigration Info, your ultimate hub for all things immigration. Looking for visa tips, country guides, and the latest immigration updates? You're in the right place. Subscribe for expert insights and join our global community today.
Today, we delve into the intricacies of obtaining green cards for family members through the I-130 petition. This guide covers everything you need to know about sponsoring family members for lawful permanent residency in the U.S., focusing on the process for July 2024, including processing times, eligibility criteria, and fees. Who can file for whom? As a U.S. citizen or lawful permanent resident, you have the ability to sponsor immediate family members for green cards. This includes your spouse, unmarried children under 21, and parents. For adult children, the process varies slightly. You can sponsor married or unmarried children of any age, but you must assume financial responsibility for them. Given the complexity of some situations, consulting with an immigration attorney is advised. Eligibility requirements. Beyond the familial relationship, there are several additional requirements. As the petitioner, you must be at least 18 years old and either a U.S. citizen or lawful permanent resident. You must also demonstrate the financial capacity to support the sponsored individual, which involves providing evidence of income and assets to meet USCIS guidelines. Processing times and fees. Good news! USCIS processing times have significantly improved in 2024. Although times can vary based on individual cases and the workload at service centers, the timeline is generally faster compared to recent years. While USCIS does not publish specific processing times for the I-130 form, reliable sources like Boundless Immigration indicate that most petitions are adjudicated within a reasonable timeframe. The current filing fee for Form I-130 is $575, with additional fees for background checks and biometrics required later in the green card process. Required documents. To file Form I-130, you need a comprehensive documentation package. Here is a checklist to get you started. Proof of your U.S. citizenship or lawful permanent resident status. This could include a copy of your U.S. passport, birth certificate, certificate of naturalization, or green card. Proof of relationship to the beneficiary. For a spouse, marriage certificate. For a child, birth certificate listing you as a parent, adoption decree, or evidence of a biological relationship. For a parent, your birth certificate listing them as a parent. Evidence of your domicile in the U.S., lease agreement, utility bills, tax returns, etc. Financial documentation. Tax returns for the past few years, pay stubs, W-2s, bank statements, and any other documents demonstrating your ability to financially support the sponsored individuals. USCIS provides detailed instructions on their website regarding specific requirements and acceptable forms of documentation. The I-130 filing process. The I-130 petition is filed electronically through the USCIS online portal. It's essential to carefully complete the form and submit all required documents. Once USCIS receives your petition, they will send you a receipt notice and begin processing. You can check your case status online using the receipt number. Next steps after I-130 approval. Once USCIS approves your I-130 petition, it establishes a priority date for your beneficiary. This date determines when they become eligible to apply for a green card visa. Depending on the visa category and your beneficiary's country of origin, there may be visa availability backlogs. We will cover visa availability and the green card application process in a future article. Stay tuned for more updates and insights on the immigration process.